Hi, everybody. Welcome. Especially to, it's a special welcome because it's our first Burger Lecture of the year. It's also special because we have a world-renowned activist and jurist and teacher and scholar with us. And then it's extra special because we also have the Dean of the Law School with us today, and he's going to welcome our speaker. So if you could join me in welcoming the Dean.
Thank you, Laura, and thank you all for coming. It really is a privilege to introduce our speaker, Justice Albie Sachs. Justice Sachs is a renowned former member of the South Africa Constitutional Court and a long-time anti-apartheid activist who worked at the very forefront of the struggle for freedom and justice in South Africa, to quickly recount a very active life. After graduating from the University of Cape Town and becoming a lawyer, Justice Sachs defended people charged with violating the apartheid statutes, repressive security laws, many of them faced with the death penalty. He himself was raided by the security police, subjected to banning orders restricting his movement, placed in solitary confinement without trial. In 1966, he went into exile, spent 11 years in England teaching and studying law, and then another 11 years in Mozambique as a law professor and legal researcher. During the 1980s, Justice Sachs worked closely with Oliver Tambo, leader of the ANC in exile, drafting the organization's code of conduct, working on their statutes, and working on preparing for the new democratic constitution. In 1990, he returned to South Africa and as a member of the Constitutional Committee and the National Executive of the ANC, took an active part in the negotiations that led to South Africa as a constitutional democracy. Justice Sachs was appointed by Nelson Mandela in 1994 to serve as a justice on the newly established Constitutional Court of South Africa, and during his 15-year tenure there, he earned a worldwide reputation as being the conscience of the court, made several landmark judgments, including the one that made South Africa the 5th country in the world to recognize same-sex marriage. In addition to his work on the court, Justice Sachs has traveled to many countries, sharing the South African experience in healing divided societies worldwide, something that he continues to do today. To take just one recent example, last year he was appointed by the Kenyan government to serve on a board to vet Kenyan judges and magistrates to ensure that the existing justices could work with the new principles of the new Constitution. As an author, Justice Sachs has published several books on human rights, including The Jail Diary of Albie Sachs, which has been dramatized on the theater and on TV, Running to Maputo, The Strange Alchemy of Life and Law, which won the Alan Paton Award, and The Soft Vengeance of a Freedom Fighter, which also won the Alan Paton Award. This past year, I'm pleased to say that Cornell University named Justice Sachs the Andrew Dixon White Professor at Large, and he will be visiting the campus in that role over the next 6 years. I look forward to the many continuing interactions we will have with Justice Sachs as the Andrew Dixon White Professor at Large. Please join me in welcoming him to Cornell. Thank you.
November 1991, I'm driving towards the center of Cape Town and I'm sweating. It was an early summer's day. Remember, we're in the southern hemisphere there. It was hot. I'm sweating because I'm driving with my left a couple of years after having been blown up by South African security agents and losing my right arm. And I'm still a bit unfamiliar. I'm sweating because I've been in exile for 24 years. First in England, then in Mozambique, then England, London, New York. And I don't even know the roads of Cape Town all that well. I'm sweating because I'm told that I should be at the usual meeting place for human rights activists, and I didn't even know, a big freedom fighter, where the usual meeting place was. But above all, I'm sweating because for the first time I'm going on a gay pride march. Oh, I wish if only we could have a poster that says straight for gays. And then I'm ashamed that I should even think that. Drive on, drive on. I'm a bit late, and I see the marchers coming towards me. And the very first poster I see, it says, suck, don't swallow. Oh my God. I'm in the newspaper tomorrow for sure. I park the car, I get out, I was still fairly weak then, and I kind of amble and run, and I join the marchers, and I get next to Professor Edwin Cameron, who's now Justice Cameron on the Constitutional Court, and I feel fantastic. I feel so proud. I feel proud that I've crossed over the barriers of awkwardness and embarrassment, and I'm marching with people who are marching for their rights. And not long afterwards, we stop at a park called the Val Park, not too far from the center of Cape Town. And I'm asked to say a few words. And I remember, as a child, I used to go there. There were signs saying whites only, but there could have been signs saying straights only. And I mentioned that. And I mentioned to the marchers that the importance of securing rights in our new constitution for gay and lesbian people is not only to prevent injustice to a section of our community, but how do we deal with difference in South Africa? If we can't manage difference and equality through difference, we are finished as a country. So in that sense, what was called then gay rights became a touchstone for something much wider than simply the rights of a section of the community who'd been subjected to completely unacceptable marginalization. It was constitutive of a living together in a future-free, democratic South Africa. That was 1991. Now we fast forward to early 2005. And now it's Justice Albie Sachs sitting at a table with my colleagues, and Pius Langa, the Chief Justice, going through the agenda, notices an item, Christian Lawyers for Africa are going to have a conference quite soon near Johannesburg, and they've invited him to attend. He says it's during the court recess, he will be out of the country. Is there anybody who will be available? I put up my hand and I say, well, Pius, I'll be on recess duty then, but I don't think I'm the right person. He says, you're absolutely the right person. And I know what he meant. Pius is Christian, he's a lawyer, he's from Africa. But if he goes, then he's going, it would appear, in a sectarian capacity. If I go, then I'm representing the court, and I'm not identifying with a particular sectarian position. Albie, you go. And a couple of weeks later, it's April, early evening, I'm being driven to the meeting place. I'm not sweating because it's cool. I'm not sweating because I'm not quite as uncomfortable, but I am feeling awkward. What do I say when I'm there? I can't just say, welcome to South Africa, I hope you have a good conference. It's banal, it's saying nothing. And these are people of conscience. I want them to get something of who we are. They register the importance of conscience for members of the court. And I'm wondering what to say. But more so because I am secular. And I have a right to my secular conscience in the same way as the people assembled there have a right to and feel extreme meaningfulness arising out of the fact that they have a theistic conscience. And that somehow, for me, that's the kind of theme that I want to convey, living in a constitutional state where you have people of different forms of conscience, but they all have conscience, which is so fundamental to every human being. What should I say? I must say, when I get to the hall and I see the people all dressed up for the opening in the beautiful costumes of Africa, already I'm feeling a little more relaxed. There's just something in the diversity, the range of cloaks and garments and men and women that made me feel very, very comfortable. Sitting up at the podium, it's my turn to speak. What should I say? And I decided to tell them about the moment when it came for me to take the oath as a judge being sworn in to uphold the Constitution, and the dilemma that I had. So I'm explaining to the Christian lawyers for Africa. I alphabetically challenged Sachs. I was the last of the 11 judges sworn in. Since then, we've had Van der Westhuizen and a Jacob, so I would have been third last. Then I'm last, and I'm watching the others. And most of them raised their right arm, say, "So help me God," and 5 different South African languages were used. It was very, very moving. But some affirmed, and ordinarily I would just affirm. When you affirm, you don't raise your right arm. And I explained to the people my dilemma, because when I took the oath to uphold the Constitution and the law without fear, favour or prejudice, the most solemn oath I could take would be to my arm, the arm of sacrifice, the arm that reminded me of Ruth First, who was blown up by a bomb in Maputo. I survived, she didn't survive. Of Lux Marcel Wandley, the first of our political detainees, tortured to death. Of another friend of mine, Bablu Salaji, thrown out of a window, held out of a window and dropping to his death. Of Jake Nabi, assassinated in Harare. That was the oath I wanted to take to the people who died so that we could get a new constitution, and we didn't live to see it. And so I told them, I decided that I would raise my right arm and say, "So help me God." That was my dilemma as a very secular person who'd fought my right as a child not to pretend a belief that I didn't have, thinking that it would be disrespectful to me if I pretended a belief that I didn't have, and disrespectful to God if God existed, to pretend a belief that I didn't have. Quite tough for a little child growing up. And I explain all that to the Christian lawyers for Africa, and I tell them I raised my right arm and said, "So help me God." They stood up and they cheered. I thought they'd be angry that I'm using my arm, the Lord's name, in vain for an instrumental, subjective purpose. The next morning, we do a tour of the Constitutional Court. We built that court right in the heart of the old Fort Prison in Johannesburg, our new building for our new democracy. And we chose the site where, as it happens, we say with a dubious pride, we have the only prison in the world where both Gandhi and Mandela were locked up. No one else can claim that. That's in Johannesburg. And that's where we built the court. So the court is right next to the prison, and the court incorporates the staircase of the prison in its very building. And we've used the bricks of the awaiting trial block to clad the court chamber as a reminder. The very bricks that were used to oppress the people are now used to protect the rights of the people. Intense, powerful symbolism. And I take 70 Christian lawyers for Africa on a tour of the building. They're very moved. At the end, And I speak to them about Ubuntu and the importance of Ubuntu, this African spirit, that I am a person because you're a person. I can't separate my humanity from an acknowledgement of your humanity, which underlies the whole project of constitutionalism in South Africa. And they seem to enjoy the trip very much. And I want to rush off because I have another meeting at the women's jail, where now the Commission for Gender Equality, created by the Constitution, has its headquarters. And I'm late, and they say, no, we must say a prayer. And some prayers are short and to the point, and some prayers go around the world a few times, and this is one of the latter. And now I'm really late, and I'm about to rush off, and they say we must lay on hands. I received their prayer, not as a believer, but as a person respecting the way it was given. They were giving what they had to give, which was their prayer and their wishes for me. I was receiving what I had and wished to receive, their love and their affection and their wish to communicate with me as I'll be. And now it takes a long time for 70 pairs of hands to be laid on, whether it's a secular body or a believing body. It takes a long time. And eventually I was able to rush off and apologize to the other meeting for my lateness. Now, why do I tell you this story? When it came to writing my book, Strange Alchemy of Life and Law, and the same-sex marriages case featured quite strongly, I realized that these were two themes of my life, representing currents, streams in my existence that didn't feature directly in the decision of the court. And I was asked to write for the court. But it's subliminally there. It's part of who you are. It's part of your makeup. It feeds into you as a person. The kinds of memories of life as lived and the dilemmas that crop up at different stages in your life. It's inchoate, it's unformed, it's not even specifically referred to. And they seem to be in total contradiction. Okay, then take that as the background. Two people in Pretoria were attracted to each other, enjoyed each other's company, started dating, they went out, they went to shows together, they fell in love, they moved in with each other, they lived together for 10 years, everybody regarded them as a couple, and they said, let's get married. And they went to the marriage officer and said, please, can we register our marriage? And he said, I would love to marry you, but I can't. You're both women. And the law says the oath that I have to ask you to repeat is I, A.B., take you, C.D., to be my lawful husband stroke wife. And husband-wife presupposes two different genders. And you have the same gender. So if it was up to me, I'd have no problem, but the law stands in the way. They said no. They went to the High Court. They demanded the right simply to be able to express their love, their commitment to each other, their sense of intimacy, wanting the public to acknowledge that they were now a couple, legally, with all the consequences that flow from that, through the law. The High Court said their hands were tied by the legislation, and an NGO called the Equality Project then went to another division of the High Court to challenge the statute. So we had the claim of this couple. It's just a simple, straightforward claim as two people under the non-discrimination clause in our Constitution. And our Constitution includes in the equality clause various grounds for that would constitute presumptively unfair discrimination if they exist, and the usual race, color, creed. It includes marital status, it includes birth, it includes national origin, it includes disability, and it includes sexual orientation. That's in the Constitution. And they said, you are preventing us from marrying because we are both women. That's unfair discrimination on grounds of sexual orientation. The problem was the statute was in the way, and they hadn't challenged the statute as such, and he couldn't himself, the marriage officer, disregard the statute because he's bound by the law. It's not for him to determine which laws are constitutional, which laws not. So both the cases are put together and they come up to the Constitutional Court. We join them. The court is jam-packed. And we have journalists from all over the world, people from all over South Africa. We hear the argument from counsel for the couple. It's very moving. Partly because it was so simple. Partly because if you wanted to invent a figure in body language and accent who represented the old guard in South Africa, you'd have just this advocate. I forget his name. You know, like you see in the films about the South, and you want to portray a real heavy-handed cop, anti-civil rights, you know, something like that. This is the kind of body language and accent that you'd expect. But in that voice of his, he's saying, justices, my clients are claiming something very simple. All that they want to do is to marry, and they say it is unfair discrimination to prevent them from doing so on grounds of their sexual orientation. It wasn't much more than that. And sometimes that very simple, laconic argument is much more powerful than an erudite presentation that draws on the wisdom of all humanity in courts from all over the world, and you still want to know, but what's the essence of it? Opposition comes from two quarters. The full frontal opposition from representatives of the Family Alliance, sent by the Catholic Church, saying that we are not opposing rights for same-sex couples. And it would be very difficult to do that in the face of the text of our Constitution. That when it comes to questions of property and tenancy and survivors' rights and so on, the law can make provision. But that's not what they are asking for. They're asking for the right to marry. And marriage, they say, marriage was an institution created by the church, by religious bodies, long before the state got involved. The state just took over an existing institution known in society, known to people belonging to faith communities. And so they said the law can protect their relationship, but don't call it marriage. We call that the M word. The case was about the M word. It wasn't about the homosexuality as such, but whether or not same-sex couples could have and should have access to the institution. Now it's the public state institution of marriage. The South African state representatives were fairly equivocal, but roughly arguing that it's not unfair to restrict the notion of marriage to the kinds of relationships that have traditionally, historically been recognized as marriage. So a fairly similar argument, but with less direct reference to a particular religious position. One person who stood up and argued with great sincerity was an advocate, Smythe, from England, settled in South Africa. And he actually quoted scripture to establish that for believers to include same-sex couples within the concept of marriage would be a challenge to their religious beliefs. because it would be somehow undermining a long consecrated and divinely based notion of marriage, a sacramental concept of marriage. And he argued that very quietly and calmly. I think the arguments lost most of a day, and we retired to consider our decision, and we workshop. I think our court is unique in the world to the extent to which it workshops. Partly we don't have the huge volume of cases that other courts have. They're under pressure all the time. But partly we're a brand new court with a new constitution, having to find new solutions to problems old and new. And we go round the table and round the table and round the table. I think we had 4 or 5 different workshops over a period of a couple of months with different drafts, propositions, ways to approach the whole issue. Everybody speaks, everybody comes in. And eventually we agree on the basic conceptual analysis. It's clear to us that to deny to same-sex couples the same access to public acknowledgement of the intimacy, their relationship, their eagerness to provide mutual support and love, their willingness to accept the responsibilities and have the public status that heterosexual couples have, is a profound form of discrimination, and it's manifestly unfair because it's based simply on sexual orientation. We agree that the basis for the unfairness is not a deliberate targeting of people for exclusion, but an invisibility. It's another way of marginalizing people through non-recognition. You can marginalize people through attacking them, identifying them, and keeping them out. But you can marginalize people by not recognizing them for who they are and excluding them from the benefits that other people who are different from them in that particular respect will get from society. In preparing the judgment opinion for the court, I was very struck by a point made in American literature about the invisibility of the invisibilizing people as a foundation for exclusion. And the example is given of a young guy coming home and saying, "Mom, Dad, there's something I've got to tell you. I'm black." And that simple little story illustrates the difference, that it's not a visible form that the basis for the exclusion, but the effect is the same. So it shouldn't depend simply on how the law is phrased. If the law says only heterosexual couples may marry, then you say, well, that is exclusionary. If the law says homosexual couples may not marry, that's targeting, that's exclusionary. But the actual written form of the law is not what really matters. It's the impact the law has on people living in society, its meaning, and on their entitlement to have access to what the law provides and offers its citizens. That is the real test. So we were unanimous. This is unfair discrimination. But that's not the end of a decision. That's the beginning of the decision. What about the remedy? And one member of the court, Kate Regan, said we must create the remedy there and then. And we create the remedy by writing in to the oath I, AB, take you, CD, to be my lawful husband, stroke wife, stroke spouse. And we'd already done that in an immigration case where we declared that the word spouse had to be written into married partners at a time when only heterosexual couples could marry. That was the law, and this is the law that's being challenged now. And we said life partners, same-sex life partners, would be covered by the word spouse, and we established criteria for establishing what life partnership meant. And Kate wanted us to do it there and then. The feeling amongst the 10 of us was no. I can only speak for myself. The judgment will speak for itself. So I can indicate my own thinking at the time, some of it being expressed. One concern I had was it would then make it appear that this was somehow a court-ordered marriage. In a curious way, would make it different from the people marrying under the statute. And if the objective is full emancipation and full inclusion in society as people participating in the ordinary way, to have that tag, this is a court-ordered marriage, would still, in the public mind, even if not in terms of legal theory, denote some kind of separation. But it wasn't, to my way of thinking, only that. This is an issue so important for, if you like, the soul of the nation. There are times when a court will dig in its heels and it will go against overwhelming public opinion. And it has to do that, defending certain fundamental rights. But there are also times when the court will encourage public engagement with the issue and members of Parliament to think about the issue. And Parliament had the same duty to uphold the Constitution that we as a court had. And so my feeling was we must bring Parliament into the process. And we must require Parliament now to understand the principles, but to leave it to Parliament to decide on the modalities. That was a separation of powers idea, but not because simply of the formal separation of powers, that we are the judiciary, we don't write legislation. There are times when we accepted that if the remedy is absolutely clear, you can write in a word or two to fulfill the overall legislative objective as expressed in the statute generally, but to bring it up to par with constitutionality, and there are no major budgetary implications, and we had a Canadian decision to back us up in doing that, and we've done that. So technically we could have done that. But my feeling was, because this is one of those issues where you are in a way campaigning for equal citizenship, not a compelled citizenship, but equal enjoyment of citizenship, the nation should be engaged and Parliament should be engaged. And that was the Parliament that included sexual orientation when it drafted the Constitution as one of the forbidden grounds for unfair discrimination. Now they must face up to the implications of what they had decreed. And it was also a kind of a challenge to almost, if you like, get out of the ghetto of simply fighting for your rights in your own limited domain and through lobbying and campaigning and denouncing and so on. Let the nation embrace the issue and think about the issue. But that also required writing the judgment in a very, what I tried to make, a very thoughtful way. Knowing that the great majority of South Africans are deeply religious. Religion means an enormous amount to them. And they will be influenced to a very large extent by their religion in the position that they take on same-sex marriages. And so much of the judgment, the part that I found the most difficult to write, to get the words just right, deals with the importance of religion in public life. Not just religion as something you can do on Sunday in your community or on your knees at night when you're praying, but religion is part and parcel of our community life. I'm secular. I sing Kosi Sikuleli Africa, God bless Africa. I was the one who proposed putting those words in our Constitution when there was a big debate about the preamble, and some people wanted to say in humble submission to a mighty God, and I felt that was oppressive to non-believers and would be divisive. But I said we can all live enthusiastically with Nkosi Sikuleli Africa, the hymn of the oppressed, God bless Africa, in all the languages of the country. It became a unifying kind of a theme. And that's the nature of the country that we live in, and the nature of my fellow citizens, the people coming before the court. And we recognize that and acknowledge that. And we acknowledge the fact that for millions of people, same-sex marriages are just unacceptable. And it's not useful to speak about the enlightened and the bigoted. We, of course, are the enlightened and they are the bigoted. And to divide the nation in a cultural war and have the battle lines drawn with no prisoners taken on either side, that can't be the role of a top court in the country to do that. We have to find a voice that speaks to everybody. And so I developed the theme of the coexistence of the sacred and the secular in one constitutional order. Not just a little reserved space for the faith, but acknowledging that that's the nature of our country, that we have religious beliefs play an enormously significant role for the great majority of our people in helping them define who they are, how they see their place in existence, their relation to creation, their moral outlook on life. These things are important to them, and I acknowledge that. And maybe because I had to fight as a child for my right not to pretend a belief I didn't have, it made me very sensitive to the importance of conscience. For me, it's number one for any human being. Before food, before the right to vote, before speech, is conscience. It's the most intrinsic feature of human dignity of any particular person. So all of that is spelled out in the decision. At the same time, it says the very Constitution that protects the fundamental rights of same-sex people to express their love and intimacy in a public way and get acknowledgement of that in a public way, the same Constitution that protects the right to have same-sex marriages protects faith communities from not being compelled to perform marriages that would go against their tenets. They're not two warring concepts. It's the same overarching Constitution that presupposes a coexistence of different belief systems in the world. And what became vital, however, was that the faith beliefs in the scripture of believers couldn't be used to determine the fundamental rights of people who don't belong to that particular faith community. All that spelled out at some length in the judgment, because it was explaining to members of the faith communities and even to the advocates and counsel who'd appeared before us that it's not a victory or defeat for a particular position in terms of same-sex relationships. It's a victory for the constitutional vision of enabling people to live as free and equal human beings in society and to make choices, if it comes to their belief systems, as to which belief system they wish to follow. Leaving it to Parliament ran two possible risks. The one is how to achieve equality. Do you equalize up or equalize down? Is it what's called equality of the vineyard or equality of the graveyard? I got this notion from my colleague Laurie Ackerman, who got it from an American writer, I forget who it was, writing I think in the 1940s. A basic issue about equality. If you want to equalize pensions, men used to get pensions later than women. Do you go up or down or halfway or whatever? It's often difficult when you have these discrepancies which are unsustainable, but how do you move to deal with them? And I don't think there is a generalized answer. But the main thrust of that American writer's argument, which we had picked up, was you go for equality of the vineyard. In other words, everything that the Constitution holds out as a protected right, you want to maximize the protections rather than avoid the problems of invidious discrimination by excluding protections from everybody. I mean, imagine if we'd struck down the marriage law so that nobody could marry except in church or in the shul or in the temple. We'd get equality, all right, equality of resentment. The gay community would say, just when we're reaching the mountaintops, they snatch marriage away from us. And the straight community could say, these damn people, we've been marrying for centuries, and now because of them, we can't marry, except in our religious communities. That couldn't be the answer. So, arguing very much for equality of the vineyard. I might say that our Law Commission had done an investigation. There was strong support for the idea of separating marriage from state-recognized civil unions. Marriage belongs to the faith communities. And for the rest, the state just has a civil union with certain consequences. But the word marriage, it's just now been appropriated by the whole of society. And you have, whether you're believers or not, you're married, you have celebrations, you have anniversaries. Imagine what the wedding gown trade would do if you limited marriage and excluded civil marriages from the word marriage. And you don't want to pick fights unnecessarily for the sake of some kind of logical symmetry. You don't want people to feel the law is this funny thing that's always interfering with things that have been going on for ages and ages, simply because of what they regard as rationality and symmetry. So that was the other thing. The other issue was separate but equal. Could Parliament say, okay, we're going to recognize the unions, we're going to give the same legal effects, but we're not going to call them marriage? And in the end, that became the kernel of the whole decision. And it would have been the easy way for Parliament to go, and they could have said there's no unfair discrimination. They're getting everything. It's just a difference in denomination. And yet the very argument used against recognizing same-sex marriages, that somehow that would contaminate, undermine, mix, dilute, interfere with marriage as recognized. I mean, what could be more demeaning than that? What could be more insulting to human dignity than to say that somehow your love and affection is worth less in terms of public recognition than that of heterosexual couples? What can do more to make people feel odd and unusual and outside and aberrant in the way that the homophobic calumnies had been presenting for ages and ages? Very, very profound. And separate but equal, we know that in South Africa. You know that in America. First of all, it was never equal. But it was so pernicious, and when the case on separate but equal came up to our top court in the 1930s, separate lines in the post office, 3 out of 4 judges said, what's the problem? You're getting your stamps anyhow, and it's a very convenient way of dividing the people. But everybody knew, and one judge stood out, and he said, no, it's a question of dignity. You are separating people because you feel that somehow to have black people standing in a queue with white people will make the whites feel uncomfortable, and the blacks feel somehow that they're equal, and the next thing they'll be asking for the vote. It was important to remind Parliament of separate but equal, and how separate but equal is never equal, and it denotes some kind of lack of common humanity and common citizenship. So that also went into the judgment. We gave Parliament 1 year in which to correct the defect. That's a power our Constitution gives our Constitutional Court. If there is a challenge to the constitutionality of governmental act or a statute, and the act or statute is shown to be unconstitutional, we are obliged to declare it unconstitutional. We don't have a choice. We can't say, well, it's very inconvenient, come back another time. We are obliged. Nevertheless, we are permitted to suspend the operation of the Declaration of Unconstitutionality for a specified period to enable the legislature to correct the defect. It's extremely valuable. Otherwise, you're scared to strike down anything. And it's also part of the conversation between the different branches of government. You point out to them, unconstitutional, these are the reasons, that's the gap. How long do you need to correct the defect? They present you with evidence, the inquiries that have to be made, the process has gone through 6 months, 9 months, 1 year. In the case of adoption, where unmarried fathers had no rights, no say in terms of the child being adopted, we gave Parliament, I think, 2 years, because that required very extensive investigation to determine the circumstances where the unmarried father was meritorious and where unmeritorious, to give some kind of indication so that fairness would result. Here we decided 1 year. It would be 1 year for national debate, 1 year for getting the community to face up to this difficult issue. And think about it. It's risky. And sure enough, Parliament went out and spoke, and many homophobic statements were made, some even by members of Parliament. But they were rebuked. And if that's the way people are thinking, let it come out, let it be countered, let it be dealt with. I was very pleased when the South African Council of Churches called the judgment a Solomonian judgment. Partly my dad was Solomon Sachs. But partly that was exactly what I was trying to do, to show it's not a judgment backing one cultural, existential position as against another, victory or defeat. It was an attempt to find a vision that enabled different worldviews to coexist in a constitutional matter in the same country. The matter comes to Parliament. One of the ANC leaders apparently stood up, I heard afterwards, and he'd remembered Simon and Cordy, who'd been imprisoned with him on Robben Island, who'd come out as gays in the 1980s. And he said there were people side by side with us in the fight for freedom. Can it possibly be right that we deny them their freedom in the new South Africa? And the ANC caucus came down very solidly in favor of supporting the provision of same-sex couples having the right to marry. There might have been 1 or 2 people who found that they had bronchitis or some illness that kept them out of the chamber, but none of them voted against. And the text of the law was in fact a Civil Unions Act which had been placed on the statutes book anyhow to allow people who wanted to register their unions, their domestic partnerships, without calling themselves married. But it allowed same-sex couples, while these proceedings are being solemnized, to say, I, A, B, marry you, C, D. So the M word came in to the text, and everybody understood this as giving same-sex couples the right to marry. It was a curious technical way of doing it, but the net result was the M word was in the Constitution, in the legislation, and now same-sex couples could marry. Not very long afterwards, 2 weeks afterwards, I'm driving, much more comfortably now, to Kirstenbosch. Any of you know Kirstenbosch? In Cape Town, beautiful botanical gardens on the slopes of Table Mountain, the most family-oriented place you can get, where you take your kids or your in-laws for a cup of tea and scones with strawberry jam and cream. And I'm looking, and there I see the notice. And the notice says, to Amy and Jean's wedding. And I felt fantastic. It was such a simple thing in this place. And I get there, Jean is South African, Amy was an American partner. They were amongst the very first to marry. And Jean told us that she had booked the reception hall, not raw, kind of restaurant. And a couple of days before, she said, I must phone just to tell them. And the manager has answered, and she said, I should tell you that we are 2 women. And the manager has said, wonderful, you'll be the first. And I actually, to be candid, I don't enjoy weddings very much. There's some people overexcited, there's lots of hidden pain sometimes, of divorced parents you don't hear about, some people get drunk. And the speeches are intensely meaningful to about 5 people and very boring to everybody else. But in this case, the more boring and banal the speeches were, the more excited I got. Where Jean's uncle, a very conservative guy, is just so proud of his niece. He's so happy for her. It reached me very much. Even when I talk now, I recall that emotion. Mark Gavissa, one of our most brilliant writers, decided that he and his partner, Chetty, should get married. Chetty was going to work for UNESCO in Paris. And Chetty said, Mark, gold. Indian tradition, I want gold. And it was like their internal joke. And quite often with people like them, who are not kind of pro-marriage as such, they find an excuse to marry. And the excuse is that it will help them for immigration purposes in Paris. And Mark writes about it afterwards. And he says he goes to the marriage office in the magistrate's court where everybody gets married. And he sees the marriage officer and he says, oh no. Again, somebody who really represents the old guard. And he said, no, this is just going to be awful. And the guy at first was very gruff, and it's the accent and the body language, very off-putting. And Mark looks around and he sees lots of little things stuck on the wall. It's a strange-looking room. And the minute the ceremony starts, this is a wonderful day for all of us gathered together in this room. It's an important day in your lives. And they get a little homily and a lecture from this guy about how important it is. And Mark says his heart is just swelling because the person whom he last thought would be capable of those emotions is now blessing their union. And then when they finish, he said, okay, now you can swap the rings. And he said, would you mind if I keep the box? Because I stick the box up on the wall. And that explained that peculiar room that he was in. We still have homophobia in South Africa. There are terrible cases of lesbian women deep in poorest areas of African community who are just beaten to death, subject to what's called corrective rape. It's awful, awful, awful. It's denounced and sometimes takes ages for the perpetrators to be captured. But by and large, same-sex marriage has been accepted. In the last country on earth, in the last continent on earth maybe that you would expect it to be, it's just accepted. That's the way people are. That's how people express their love for each other. And we as South Africans are better people, all of us, straight and gay, because we accept that. Thank you.
Would it be okay if we have a couple questions?
Sure.
All right. So we have just 5 minutes before we get kicked out if there's any questions.
Albert, thank you for a wonderful discussion, set of stories. I think, a hard question for you. So, the South African Constitution, unlike our Constitution, has horizontal effect. So, have you had cases like the ones that led to some delays in the enactment of the New York marriage legislation, where there are not government officials, but other people, like the New Mexico case just a few weeks ago, wedding photographers, bakers, florists, who say they don't want to participate. And, how do you reconcile that with the horizontal effect of the
Right. We have indirect, we have what I call diagonal effect. because our Constitution says the common law must be developed in keeping with the Constitution, and all legislation must be interpreted in keeping with the Constitution. So that, to a very large extent, deals with the intense debates in academia in the United States about vertical and horizontal. What is the Shaughnessy? What's that famous case of where the state couldn't be held liable because of the kid who was killed, had been awarded. DeShaney, yeah. We don't have those issues. The fact is that this question of coexistence did crop up in the decision, where the decision that's now written by me says that in the spirit of reasonable accommodation, the legislature might consider that to compel a marriage officer to perform a marriage ceremony that went against his or her religious beliefs mightn't be appropriate, and that some kind of exemption could be granted in those circumstances. And part of the motivation was double. One was to prevent people coming forward as martyrs to try and scupper the whole project on the basis of it is a violation of my religious beliefs. But also, if you're being married by somebody who's loathing the ceremony, it's just not going to be right. And I like the principle of reasonable accommodation. It actually grew in disability law in a very attenuated, weak form in the United States. We've developed it much more. And reasonable accommodation means people talking to each other and finding solutions that are appropriate and respectful, rather than red lines, drawing red lines in the sand, which I believe is a favorite American pastime these days.
Thank you very much. I noticed that the couple that you were talking about in this important case had the support of the Lesbian and Gay Equality Project. Mike and I have done some research with similar groups in the United States.
Can you all hear?
Everybody hear me? Mike York and I have done some research with similar groups in the United States this year, and we were pleased to find that many of the groups had been active supporting